Under the Voting Rights Act, codified at 52 U.S. Code Section 10101A1, all citizens of the United States who are otherwise qualified by law to vote shall be entitled and allowed to vote at all such elections without distinction of race, color, or previous condition of servitude. Under 52 U.S. Code Section 10101(2)A, no person acting under color of law shall, in determining whether any individual is qualified under state law or laws to vote in any election, apply any standard, practice, or procedure different from the standards, practices, or procedures applied under such law or laws to other individuals within the same county, parish, or similar political subdivision who have been found by state officials to be qualified to vote. Under U.S. Code Section 594, whoever intimidates, threatens, coerces, or attempts to intimidate, threaten, or coerce any other person for the purpose of interfering with the right of such other person to vote, or to vote as he may choose, or of causing such other person to vote for or not vote for any candidate for the office of president, vice president, presidential elector, member of the Senate, member of the House of Representatives, delegate from the District of Columbia, or resident commissioner at any election held solely or in part for the purpose of electing such candidate shall be fined under this title or imprisoned not more than 1 year or both. Under 18 U.S. Code 241, if two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, or because of his having so exercised the same, they shall be fined under this title or imprisoned not more than 10 years or both. And if death results from the acts committed in violation of this section, or if such acts include kidnapping or an attempt to kidnap, aggravated sexual abuse or an attempt to commit aggravated sexual abuse, or an attempt to kill, they shall be fined under this title or imprisoned for any term of years or for life, or both, or may be sentenced to death. Moreover, pursuant to 52 U.S. Code Section 10101B, no person, whether acting under color of law or otherwise, shall intimidate, threaten, coerce, or attempt to intimidate, threaten, or coerce any other person for the purpose of interfering with the right of such other person to vote or to vote as he may choose. Under Pritchard v. United States, it is the rule that all parties to a conspiracy need not be named in the indictment. If the indictment charges a conspiracy among named defendants and other persons unknown to the grand jury, it appears at the trial that there was such conspiracy, but that only one of the named defendants was a member of it. It is sufficient to support a conviction if it is shown by substantial evidence that the parties unknown at the time the indictment was returned had committed overt acts therein alleged. Under Castro v. U.S., the overt act in a conspiracy need not be a crime and is not a part of the offense charged, but simply something done in furtherance of the object of the conspiracy. In United States v. Elliott, the court stated, "We recognize that once a conspiracy is shown to exist, slight evidence is all that is required to connect a particular defendant with the conspiracy." The court in Elliott continued, "Direct evidence of agreement is unnecessary. Proof of such an agreement may rest upon inferences drawn from relevant and competent circumstantial evidence, ordinarily the acts and conduct of alleged conspirators." Additionally, as stated before, once the conspiracy has been established, the government need only show slight evidence that a particular person was a member of the conspiracy. Of course, a party to a conspiracy need not even know the identity or even the number of his confederates. Under U.S. v. Heard, a defendant is presumed to continue his involvement in a conspiracy unless he makes a substantial affirmative showing of withdrawal, abandonment, or defeat of the conspiratorial purpose. In order to show withdrawal, the defendant must show that he has committed affirmative acts inconsistent with the object of the conspiracy that are communicated in a manner reasonably calculated to reach other conspirators. Mere cessation of activity in furtherance of the conspiracy is not sufficient to show withdrawal. In remedy thereof, as authorized under 52 U.S. Code Section 10101E, whenever any person has engaged or there are reasonable grounds to believe that any person is about to engage in any act or practice which would deprive any other person of any right or privilege, the Attorney General may institute for the United States a civil action or other proper proceeding for preventative relief, including an application for a permanent or temporary injunction, restraining order, or other order, pursuant to this same provision, whenever any official of a state or subdivision thereof is alleged to have committed any act or practice constituting a deprivation of any right or privilege. The act or practice shall also be deemed that of the state, and the state may be joined as a party. My name is Major Mike Webb, retired Army Ranger, and I am running for U.S. Congress. With liberty, honor, and excellence, by God, we shall make America great again. Honest. Honest. This advertisement was authorized by Mike Webb. Honest.